Welcome back to The Explainer. Today, we're jumping right into one of the most high-stakes games played on the global stage, international investment law. We are talking about the hidden treaties and the complex strategic maneuvers that literally decide the fate of billions of dollars across borders. If you've ever wondered how massive corporate investments are protected or, completely lost when they cross international lines, you are in exactly the right place.
Okay, let's take a quick look at our roadmap. We'll start with an overview of international investment, cover the basic treatment principles, define the protection standards, explore the exceptions, and then finally wrap up with practical legal consulting skills.
So, Act 1, the map. Let's define the playing field.
To start things off, definitions are absolutely everything in international law. Seriously, if you don't fit the precise definition, you just don't get the protection. The very first major distinction we need to make is between FDI and FPI. Foreign direct investment, or FDI, requires a quantitative threshold of at least 10% equity and, this is crucial, direct management control of the daily operations. On the flip side, foreign portfolio investment, FPI, is basically just buying shares or bonds through intermediaries. You aren't stepping in to manage the company. Understanding which of these two buckets your investment falls into totally dictates the legal framework that applies to you.
Now let's define the real protagonist of our journey, the foreign investor. For a human being, nationality is pretty straightforward, right? It's just based on their citizenship. But for a massive multinational corporation, it gets incredibly tricky. Are they defined by where they're incorporated, or where their headquarters are located? Or maybe by who actually controls their capital? Modern treaties scrutinize these criteria very carefully to prevent companies from just spinning up empty shell corporations solely to get favorable legal treatment.
Moving right along to Act 2, the rules of the game, basic treatment principles.
The most famous of these rules is national treatment. Basically, this says a host country cannot treat a foreign investor worse than its own domestic investors. As a consultant, your job is to systematically apply this crucial three-step checklist. First, you've got to find a domestic subject in like circumstances. Second, you apply the relevant laws to see if there's any difference in treatment. And third, check if there's a justifiable exception. A classic example here is the Occidental versus Ecuador case. The tribunal actually had to decide if a foreign oil extracting company was being treated unfairly regarding VAT refunds. The key was comparing them directly to domestic producers in identical like circumstances. I mean, if the domestic guys get a tax break, the foreign guys should too, unless there is a highly specific legal exception.
Now, it's really fascinating to look at the evolution of the most favored nation, or MFN principle. MFN simply means you have to treat an investor from one country as well as you treat your most favored partner from any other country. Older bilateral investment treaties granted this really broadly. But new generation free trade agreements, things like the CPTPP or the EVIPA, they show a very clear trend towards strictly limiting these broad privileges. Most importantly, modern agreements often explicitly exclude investor-state dispute settlement, or ISDS, from MFN clauses entirely. Countries are getting much more protective of how and when they can be sued.
Let's dive into Act 3, the shields, core protection standards. So these protections build into two massive pillars of international law: fair and equitable treatment, which we call FET, and full protection and security, or FPS. And let's be clear, these are not just abstract acronyms floating around in a textbook. They are concrete guarantees. They protect investors from coercion, harassment, or a denial of justice in local courts. Furthermore, FPS demands that the host state exercise due diligence to physically protect the investment from things like riots or civil unrest. Think about it. If a factory is burned down because local police just stood by and did nothing, the host state has very likely violated the FPS standard. And the quoted text defining FET beautifully captures its very essence: protection of the legitimate expectations. What does that actually mean in practice? Well, it means if a host state lures an investor in with specific legal promises and then suddenly pulls the rug out from under your client by arbitrarily changing the regulatory environment, FET acts as a massive legal shield. You simply can't change the rules of the game arbitrarily once the capital is sunk into the ground.
But what if the state goes even further? Imagine your client actually faces expropriation. You really need to distinguish between the two types here. Direct expropriation is easy to spot. It's a blatant physical seizure of assets or a formal legal transfer of title. Boom, it's gone. But indirect expropriation?
that is far more common and far more subtle. It's essentially death by 1,000 bureaucratic cuts. We're talking about the government denying essential operating licenses or imposing arbitrary astronomical tax hikes that just slowly suffocate the business until it's effectively worthless. Both are expropriation, for sure, but the indirect kind requires a highly skilled consultant to successfully prove in a tribunal.
Here is a huge reality check, though. A host state absolutely can legally seize a foreign investment. It is their sovereign right. However, they must strictly adhere to 4 specific conditions. It must be for a legitimate public purpose, it must be non-discriminatory, it must follow due process, and, here's the biggest one, they must provide prompt and adequate compensation. If a state seizes an asset and misses even one of these 4 conditions, it triggers a massive treaty violation.
Which brings us to Art 4, the rule benders, exceptions and resolutions.
Because, as you might guess, the rules aren't completely absolute. Modern agreements explicitly codify exceptions because states learned the hard way that they need breathing room to actually govern. Treaties carve out general exceptions to protect vital things like public morals, human health, and the environment. This draws heavily from principles established in global trade agreements like GATT and GATS. So if a state bans a toxic chemical to protect its water supply, and a foreign factory loses money because of it, the state can and will invoke these exceptions to defend itself against a lawsuit.
But applying these exceptions? That is highly contested in reality. This is perfectly highlighted by the CMS versus Argentina case. Argentina suffered a catastrophic economic crisis and took emergency measures that really hurt foreign investors. When they got sued, Argentina claimed an essential security interest exception. The massive legal debate was, does a severe economic meltdown legally qualify as an essential security interest in the exact same way a war or a military threat would? Cases like this prove that interpreting these exceptions is literally one of the most complex battlegrounds in international law.
Finally, let's move to Act 5, the strategy, practical legal consulting skills.
So to transition from all this theory into real-world practice, you have to rigorously follow this 4-step consulting process. First, research the case-specific facts. What exactly is the client doing? Second, identify all the applicable bilateral or multilateral treaties. Third, dive deep into analyzing the precise legal provisions. Does the treaty include broad FET, or does it have narrow exceptions? And finally, draft your strategy and risk mitigation plans. You are essentially matching your client's specific operational facts with the correct international treaty provisions to build a bulletproof fortress around their capital. Ultimately, your absolute highest value as a consultant comes from anticipating the future. It's all about strategically structuring investments upfront to maximize tax and protection benefits. It's about looking at a host state's political climate and accurately assessing the real risk of policy changes or creeping expropriation. And crucially, it's about actively dodging the denial of benefits traps that are hidden in modern agreements like the EVIPA or CPTPP. Under those agreements, a state can entirely deny treaty protections if an investor is just a shell company with no substantial business activities.
And that brings us to our ultimate question. The landscape is fundamentally shifting. The old, broad protections are rapidly being replaced by strict, modern agreements that favor state sovereignty and highly precise definitions. So, with new generation treaties actively reshaping the rules of a game, is your cross-border investment strategy truly protected? I challenge you to view any future international deals through this critical, structured lens. That's all for today's Explainer. Keep learning, keep analyzing, and I'll see you next time.